My story this morning involves a pissing match between the tobacco company that holds a trademark for Raw and the cannabis company that is trying to get a trademark for Raw Gardens. And BBC is the cannabis company, though. I mean, the tobacco company has Raw, and they sell rolling papers and trays and rolling machines and machines to shred up tobacco and all that kind of stuff. But a lot of people buy Raw rolling papers in the cannabis industry, and they kind of sort of, advertise that direction. Well, Raw filed a suit against this CCA is the name of this company, and they said you're infringing on our trademark here for Raw. Okay, and the court took a look at it and said, well, I don't think there's any confusion here between these two trademarks. So the court dismissed the case against CCA for the claim they were infringing on Raw's trademark. But then they also took a look at Raw Gardens and said, well, look, you guys are being attacked by or opposed by someone who has a registered trademark for Raw. Okay. And you have 4 applications pending at the trademark office. So we're going to take a look at all of those applications. And this is where many of my friends in the trademark line got a little upset, and they said, well, I'm not sure that we like them doing that, because there's an entire process at the trademark office where you file an application. You're supposed to tell them whether this is first use or whether you're intended to commercially use it. And it seems that Raw Gardens didn't check that box. They didn't say, well, we intend to use this commercially. So rather than wait until the Patent and Trade Trial Office had litigated this, decided they were going to give you a trademark or dismiss it, the court stepped in and dismissed all these trademark applications. Now, I'm not sure that I understand all the import of this. And I've said before that if you have a trademark issue, you need to get a trademark specialist, because there are apparently jurisdictions in this country, the federal jurisdictions. These are the trial courts and the appellate courts don't allow a district court to take a look at what's pending before the Patent and Trade Office. But it seems that there are that allow this. So this is going to probably have to make its way up to the Supreme Court to see if challenging a trademark is going to allow the court to take every application before the trademark office and take a look at it in their trial court and then decide if they're going to dismiss them all. Now, one of the takeaways from this, and I'm going to say this again, that if you are going to have a trademark for your cannabis business, you can only register them for cannabis statewide. But I know cannabis. I mean, I know trademark attorneys that do cannabis. Go to the Patent and Trademark Office, and they'll register trademarks for a lot of other merchandise that's not cannabis merchandise, so that there are trademarks out there. I don't know if what they dismissed were applications like that. That could put a wrench in a lot of the patent attorneys that I know in how we try to get people's names out there nationally and not just be a statewide brand. So I'm going to throw this back at you guys. Now, Luke, I know that you just started a brand, so you've probably been dealing with some of this stuff. I'm interested to see what your experience is. But get a good trademark lawyer if you're going to have a trademark. I'm throwing it back at you guys. What do you have to say?
I mean, trademark, I'm so glad that you differentiated the difference between the need for state versus federal, because federal is kind of like a joke for cannabis businesses right now, right? But it's so critical, right? Because your brand is everything right now. And so Dale, geez, you should have a list of trademark attorneys in your pocket. I just sent you a text message, actually. I'm curious to know who you would recommend. But it's incredibly important, especially in this day and age, that if you are not documenting the nature of your business from a visual standpoint, from a name standpoint, you're just shooting yourself in the foot, because there's only so many clever words that can tie to this plant, right? There's only so many plays on words that you can come up with. And you have to be able to protect it in some manner.
Now,
well, and trade dress is a lot of this, Mandy, is that it's not just the word, is it what are the colors surrounding it, the patterns around it, and are you trying to take somebody else's color scheme and patterns and appropriate that? That typically gets done in the patent office and through their trial. They call them iterations. You'll make an application, say, no, this is the color you're using is too close to some other color. You got to do another color. You do another application, and they make their way through this. That, I think, needs to stay at the patent office, but that's my opinion. And I do have names of some attorneys. If people want to contact me, I can put you in touch with some patent and trademark attorneys.
Okay.
So it's interesting that you bring that up, Dale, because Nick in the chat, he's like, they don't capitalize the letters like raw, and the color scheme is completely different as well. And I personally agree with that. Like, they don't have a patent or a trademark on the word raw. I mean, if that's the case, they should be suing like Whole Foods and all these other raw food restaurants and everything.
Oh, but that's one of the.
Isn't there a component of how the brand is used too? Like, it has to be somewhat related. So, are raw papers? They're not actually sold as cannabis paraphernalia, right? Because that would still be federally illegal. They're sold as tobacco paraphernalia. Is that
Sold
right?
as tobacco paraphernalia.
Yeah, they have a tobacco exception for it. Yeah.
Real quick, Dale.
Like funny. I was just. Go ahead.
No, go ahead, man.
I was just saying, Luke and I were just saying the other day that we didn't remember. We were like, "Oh, whatever happened to Raw? Like, they just disappeared for a minute, and here they are. They're back.
They're back. Back with another lawsuit.
They've been tied up in litigation for like the past 2 years.
Yeah, they've been tied down, more like."
I know. I think when I got out, you guys covered my story and Raw's story, I think, on the same day or something like that. I remember the Raw thing circulating right around when I got out around February last year a lot too. But I have a question for you, Dale, real quick. I know there is a standard or threshold on like what can be trademarked. Like I read a case about like somebody was trying to trademark the word it was Ohio State. It was Ohio State was trying to trademark the word Ohio State, right? And they were trying to make it to where nobody else could use it. And the court said, listen, that's just too common. The word has too many common uses. I think they was the standard that they used. But maybe you can talk more to that, Dale. Is there something something is such a simple or a commonly used term that they can't trademark?
There absolutely is. And the attorneys I work with want a unique word, something like Shazam or something like that doesn't have common use, okay, that you can actually capture that. Because there are so many common words. That's the first discussion that takes place with these patent attorneys. They take a look at your proposed trademark and go, look, this name you can't patent or you can't trademark. That word you can't because they're just too common. And at the trademark office, they will take a look at their list of all the similar names and see, are you close? And that's part of the iteration process to go, that's too close to this one. Change a word here, different spell it, change the trade dress around it, something like that. And if the attorneys lose this, I don't know what that's going to mean. So, yeah, it's a problem. I don't know how to address that, Luke, because there's so many common words.
Yeah, let's look at what the most popular brands are, though, right? Like, they're companies like Nike, Adidas, Amazon. Words that are not necessarily, like, yes, they are words that have meaning historically or geographically or whatever, but they're not words that are necessarily used in common vernacular, right? So,
well, Amazon is.
That would be
Amazon is.
I mean, it is now because of the company.
It is now, yeah.
I'd say it is because everyone talks about saving the rainforest.
Or Google, for example, is another one that, yes, it has some meaning, but it's not really used out until it was adopted by a company. So that's always been my view on that. I'm not necessarily a marketing person, but I feel like using names that are not likely to be used again, or where it's very obvious that somebody is ripping off your name.
Yeah, I don't know, man. One could argue, I'm not making the argument, but one could argue that trademark law in itself stifles creativity and stifles progress.
Oh, man.
But that's baked into our Constitution.
Yeah,
they have intellectual property rights.
I see.
I'm not personally making the argument, but
I mean, listen, I'm all for the free market. I'm all for it, but I think
is the reason why China, without IP and without a patent law, China has blazed past the rest of the world in less than 3 decades because of their lack of patent and IP law.
Cute.
Did you not make that argument?
Cute.
Just saying.
No,
Yeah.
because they're just thieves. They just steal it.
Yes.
They just steal all of our shit.
Well, the
So
world
no.
is all about. You can argue that the progress over humanity several times over is all about stealing other people's shit, reproducing it, and selling it as your own.
Well,
Yeah,
and
but when you get caught, you shouldn't get away with it.
this is my thing. This is what my little piece of advice that I will just drop on this conversation, and you can pick it up or leave it or drop it and throw it in the trash. I don't know, but okay, let's say we start this brand called Mandy Tingler, right? And the brand is called Mandy Tingler, and it's doing well. And then
It doesn't have to be Tingler.
and then another brand comes up, right? And it's called Mandy Tingler too, because they want to capitalize and try to bootleg and make money off of that brand's name, right?
Bootleg it, baby. Go ahead.
But this is the difference, at least in the cannabis space, right? A lot of things don't transfer from the corporate world into the cannabis industry, and some of it does, but this is, I think, one of the spots where it doesn't. Is in the cannabis space, people know Mandy. People know the authenticity of Mandy's brand. They know what she put into it. They know her work. They know her story behind it. They know all these things. They know what kind of care goes into it. They know Mandy's expertise in the market. They know she's a cannabis connoisseur. They see the other brand too. They know that's not Mandy's brand, or even if they do, they say that's suspect, right? What's going on over there? This is my point, is that authenticity matters in the cannabis space. So your brand, regardless of it, I'm going to go over to Mandy Tingler's real brand because it auras with the authenticity of her stuff, right? Now, in a different space, in a apparel space, right? A black Nike t-shirt with the Nike symbol on it, right, is a black Nike t-shirt with the Nike symbol on it, no matter where I get it from, the docks in San Francisco or from the Nike outlet in Gilroy. It really is the same thing to me. There's not an authenticity to it that I have to say. I mean, there's an authenticity to it, of course, but of a shirt versus a bootleg, but there's not some like I'm not going to that brand and saying, oh, like I know this brand, I know this person, I know what goes into this. Like none of that happens when I'm doing that. That's where I'm saying that it doesn't transfer. So my point is this, is people could bootleg, people could take your brand, they can say it and they can call anything they want to. But if you represent your brand and your company in a way that nobody else can and bring that authenticity, guess what? Nobody can dub that.
Yep.
Nobody can.
Yep. And on one thing, I do want to give a shout out to Adam, who knew what Nike meant, because I had no clue what Nike
it's a
Greek goddess of victory. Shout out Adam, throwing that in the chat.
Yeah.
Appreciate that.
Individual.
We got to go to a
Name has
commercial.
been thrown out as an option for almost every women-owned brand ever.
Yeah, we got to go to a commercial. We're going to be right back.